Welcome to the YouTube channel of Legally Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's video, let us talk about stabilization. Are there rules on price stabilization and market manipulation in connection with an equity offering? The SEBI issue of Capital and Disclosure Requirement Regulations of 2018 provide for a green shoe option as a mechanism for price stabilization during an IPO. Under this option, a company can over-allot up to 15% of the issue size shares to investors participating in the issue with a view of having the merchant banker buy them back from the open market after listing. The objective of this mechanism is to reassure investors that they have an exit available during the first 30 days after the listing of share price at a price close to the issue price due to the price stabilizing activity of the merchant banks. Manipulation is regulated under the SEBI Prohibition of Insider Trading Regulations 2015, which prohibit any person from using any manipulative or deceptive device for the procurement of any securities or sale of securities of a company. The SEBI Prohibition of Fraudulent and Unfair Trade Practices relating to Market Regulation 2003, which is also known as Unfair Trade Practices Regulations, which list unacceptable conduct in the securities market. Chapter 2, Subclause 3 of the Unfair Trade Practices Regulation prohibits unfair dealings in securities and provides that no person can directly or indirectly buy, sell, or otherwise deal in securities in a fraudulent manner, use or employ in connection with issue, purchase, or sale of any security listed or proposed to be listed in a recognized stock exchange, any manipulative or deceptive device or contravents in contravention of the provisions of the Securities and Exchange Board of India Act 1992, the SEBI Act, or the rules or regulations made under it, employ any device, scheme, or artifice to defraud in connection with dealing in or issue of securities that are listed or proposed to be listed on a recognized stock exchange, engage in any act, practice, or course of business that operates or would operate as fraud or deceit or any person in connection with any dealing in or issue of securities that are listed or proposed to be listed on a recognized stock exchange in contravention of the provisions of the SEBI Act or the rules and regulations made under it. Now let us understand tax equity issues. What are the main tax issues when issuing and listing equity securities? Stamp duty is payable on the issue of securities. Other than that, there are no tax issues when securities are issued and listed in India. What are the main areas of continuing obligations applicable to listed companies and the legislation that applies? Before the introduction of SEBI, Listing Obligations and Disclosure Requirements Regulation 2015, which is also known as the LODR regulations, entities that sought to list their specified securities on a recognized stock exchange entered into a listing agreement with the stock exchange and covenanted to comply with the conditions laid out in the agreement. Compliance with the listing agreements were monitored by the stock exchanges, with regulatory oversight being provided by SEBI. However, SEBI notified the LODR regulations in September 2015 in order to harmonize the existing post-listing compliance framework and develop a set of comprehensive regulations for various types of listed securities. The LODR regulations are applicable to all listed entities that have listed equity shares, non-convertible redeemable preference shares, Indian depository receipts, or securitized debt instruments on a recognized stock exchange. A significantly shortened uniform listing agreement has been prescribed under the regulations. The LODR regulations provide a set of broad principles that are in line with the International Organization of Securities Commissions, that is the IOSCO, principles for periodic disclosures, and also incorporate the principles for corporate governance in line with Organization for Economic Cooperation and Development, that is the OECD principles. They prescribe certain common obligations that are applicable to all listed entities, such as appointment of a compliance officer and a share transfer agent, cooperation with the SEBI registered intermediaries, preservation of documents, technological infrastructure, grievance redressal mechanisms. Entities that have listed their equity shares on a recognized stock exchange must comply with the following obligations, among others. Corporate governance. The board of directors must have an optimum combination of executive and non-executive directors with at least one female director. While not less than half the board must comprise non-executive directors, not less than one-third must comprise independent directors. If the chairman of the board is an executive director, a promoter, or a person related to a promoter, then at least half of the board must comprise independent directors. The recent SEBI listing obligations and disclosure requirements amendment regulations 2018 introduced a requirement that the chairperson of the board must be a non-executive director and not be related to the managing director or the chief executive officer. This amendment came into effect from 1st April 2020 for top 500 listed entities by market capitalization. However, this requirement is not applicable to listed entities that do not have any identifiable promoters as per the shareholding pattern filled with stock exchanges. The LODR regulations also prescribe the composition requirements and term of reference of certain critical corporate governance committees such as the Audit Committee, Nomination and Remuneration Committee, Stakeholders Relationship Committee, Corporate Social Responsibility Committee, Risk Management Committee. Related party transactions. The LODR regulations require that every listed company put in place a policy on materiality and on dealing with related party transactions and require the prior mandatory approval of the Audit Committee for such transactions. All material related party transactions also require an approval of the non-interested shareholders, that is, a resolution on which the related parties cannot vote. Periodic reporting. The listed entities must make a number of filings with the stock exchanges on a periodic basis. These include the following: a quarterly compliance report on corporate governance within 15 days from the end of each quarter, a statement giving the status of investor complaints within 21 days from the end of each quarter, quarterly and year-to-date financial results including the income statement and balance sheet in a prescribed format within 45 days from the end of each quarter other than the last quarter, along with a limited review report or audit report as applicable, a compliance certificate certifying the maintenance of a physical and electronic transfer facility within 1 month of the end of each half of the financial year, audited standalone financial results along with audited consolidated financial results if the entity has any subsidiaries for the financial year within 60 days from the end of financial year along with an audit report, an annual report within 21 days of it being approved and adopted in the annual general meeting under the provisions of the Companies Act. Under the provisions of Regulation 55A of the SEBI Depositories and Participants Regulation 1996, listed companies must also submit a reconciliation of share capital audit report on a quarterly basis to the stock exchanges for the purpose of reconciliation of the share capital held in depositories and in physical form with the issued or listed capital. Other compliance requirements. The LODR regulations also prescribe certain other disclosures that must be made before the occurrence of or on the occurrence of certain events such as board meetings for discussing certain prescribed matters, voting results, and price-sensitive information. Do the continuing obligations apply to listed foreign companies and to the issuers of depository receipts? The SEBI Listing Obligations and Disclosure Requirements Regulations 2015 are also applicable to foreign companies that have listed Indian depository receipts, that is the IDRs, on a recognized stock exchange in India. Such foreign companies must promptly disclose all events that are material or information that is price-sensitive, submit an IDR holding pattern within 15 days at the end of each quarter in the specified format. However, the LODR regulations are pragmatic as they enable a foreign company whose security market regulator is a signatory to the Multilateral Memorandum of Understanding of the International Organization of Securities Commission, that is the IOSCO, to manage its affairs in accordance with the continuous disclosure or compliance requirements of its home country in a number of matters such as periodical financial results, annual reports, and corporate governance requirements. A foreign entity must also ensure that for all corporate actions except those that are not permitted by Indian law, it treats IDR holders in a manner equitable with the security holders in its home country. What are the penalties for breaching the continuous obligations? If a listed entity or any other person within that listed entity contravenes any of the provisions of the SEBI Listing and Obligations and Disclosure Requirements Regulation 2015, it is liable for an action under the securities laws, fines, suspension of trading, freezing of promoter or promoter group holding of designated securities, or any other action specified by the SEBI. SEBI has notified a uniform fine structure for failure by listed companies to submit periodic reports and a standard operating procedure for suspension of specified securities. In addition, the stock exchange, which are responsible for monitoring compliance by listed entities with the provisions of the LODR regulations, must disclose on their websites details of the action taken by them against instances of non-compliance. Hope this video was informative. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.